Article 89 of the Constitution, to the extent that the elections of an extra constituency not defined under Article 97 took place during that particular time, that contaminated the election. You must then ask yourself, to what extent was the contamination? Article 138, Clause 4 requires the Commission to compute whether or not the president-elect has attained 50 plus 1%. We are submitting that these elections that took place in alien constituencies contributed to the computation of 50 plus 1%. Then you might ask yourself, my ladies, my lords, what then is the test that I'm trying to apply? I am applying the test proposed by Section 83 of the Constitution of the Election Act. It provides that an election can be voided if that election did not comply with the Constitution or other written law. And this is a fundamental question, my ladies, my lords, because a constituency as defined by Article 289, Article 89, that must be within the territory of Kenya as defined by Article 5, then contemplates a situation whereby there is a question of representation. It subjects the people of Kenya to exercising their sovereignty through the representation of those people. The question then that begs an answer is, how can an election that has been infiltrated by alien constituencies be regarded as a constitutional election? We submit thus that waives the fundamental requirement where IBC under Article 88, Clause 5, is required to conduct an election within the armpits of the Constitution. It is a mandate within the IBC that the mandate is so fundamental that it cannot be waived, it cannot be fettered, it cannot even be relaxed. An individual cannot create a constituency. If it was in the interest of Kenyans, while promulgating this constitution and adopting this constitution and giving this constitution unto themselves to create an extra constituency, there was nothing that was as easy as saying as such. My ladies, my lords, permit me to address the question of the 27 constituencies. Again, it has been submitted by my learned friend that under paragraph 25 of the Chairman Chebukati's replying affidavit, he has glossed over that weighty issue. He does not consider that 27 constituencies, which makes about 10% of the Kenyan constituencies, which translates to about 1.9 elected voters, were not included in the final tally. And what does he do? He makes and he amends and carefully uses the words which to apply. In his replying affidavit, he technically avoids the use of the word declaration and he uses the word announcement. The word announcement is not akin, is not similar, and does not mean declaration. Why, my ladies, my lords? Because Article 138, Clause 4, presupposes a declaration of all the polling results by the IEBC. So this declaration is not akin to announcement. And therefore, my ladies, my lords, we are submitting that the chairman of the Electoral Commission was lost on what he needed to do. He is making a declaration and reducing the question of declaration to the question of a master of ceremony. The IBC chairman was not called upon to just officiate the process. He was called upon to execute a constitutional obligation. And therefore, when the law speaks about a declaration, there must be clear demonstration that the same was done. What happened, my ladies, my lords? He says that the law does not require him to do so. He does not annex any evidence that the same was declared. He does not annex any evidence in his affidavit that there was tallying. He does not aid this honorable court to make an opinion that, yes, the requirements of the Constitution were met. Finally, my ladies, my lords, we need to interrogate the conduct of the chairman of the IBC. We need to interrogate the previous and even the current conduct of the chairman. He was effectively described by my senior line friend, Mr. Norji, That is a person who has perfected the art of imperfection. And he has perfected the art of imperfection by making sure that he conducts a lone ranger process. Remember, my ladies, my lords, to the run-up of the second election in 2017, a similar issue arose, which necessitated the resignation of the commissioners. How long shall we allow an individual to keep on transgressing the law? How long shall we allow this individual to keep on putting Kenyans and to subject Kenyans into uncertainty? The law requires that there must be certainty. And the certainty contemplated by the law is that I shall cast my vote, and my vote shall count. And why are the 27 constituencies fundamental and key to these proceedings? If you look at our paragraph 57, 52, 53, and 54, we have listed those constituencies. It is where an individual or the first petitioner has his supporters. It is where he has his support base. So were they left out as a matter of design? Were they left out by default? Or was he holding someone's brief? My ladies, my lords, we submit that to the extent that those constituencies were not tallied, were not verified, and the declarations were not made, then this election did not meet the provisions of the Constitution. Finally, my ladies, my lords, he says in paragraph 25 that he can announce elections anytime that he so wishes, even if there are some constituencies that have not generated their results. But what does section 39, subsection 2 of the Election Act provides? It provides, my ladies, my lords, I would wish to read this. The chairman may declare a candidate elected as president before all constituencies have transmitted their results. The operating word here, my ladies, my lords, is the word before. So if before, at the time he's declaring those elections, the constituencies have not generated their results, he can declare. But the situation where we are in, my ladies, my lords, on 9th, going by the dictates of Maina Kiai's case, the chairman had received all the results from the polling stations. It was therefore incumbent upon him to make sure that they are included, to make sure that they are tallied, to make sure that they are verified. Finally, my ladies, my lords, permit me to delve on an issue that was dealt with in the morning by my senior learned friend, Mr. Governor Orengo. My ladies, my lords, I am referring to the replying affidavit filed by Honorable William Ruto, and I'm referring to page 111, where it indicates a preliminary statement of the IGAD Election Observation Mission to the August elections. And that paragraph, my ladies, my lords, these were individuals who are observers of the elections, who are out there observing the elections. When it came to the question of analyzing the voters' turnout, the report says, it is annexed in its affidavit, that in most of the polling stations visited, voters' turnout was noticeably low and recorded around 55%. Those were observers out there in the field observing the elections, giving a return of the 55%. And this 55%, and you can see how this computation of the turnout is fluid. It is so fluid, it's a lever. You are not able to hold it. The chairman is not able to tell about the voters' turnout. The report is giving us a different voters' turnout. So what exactly was the voters' turnout? So that the voters' turnout then can assist us in the computation of the sum of 50 plus 1%. Finally, my ladies, my lords, there's a question as to the computation of the 50 plus 1%. That when the chairman gave his final public address about the voters' turnout, he deliberately exempted those individuals who voted manually. To date, We are not aware of how many people passed through the manual registration. How many people voted manually? I mean, my ladies, my lords, it is not within the armpit or within the purview or within the power or the discretion of the chairman of the Electoral Commission to do that what he wishes. He cannot deal with the question of elections from his aspirations or from his wishes. He must deal with the question of election as dictated by the Constitution, as dictated by the election laws. Finally, my ladies, my lords, we urge you to admit our petition and you dismiss the replies filed by all the respondents and find that this election was not conducted in accordance to the Constitution. And my ladies, my lords, that you give an order that the sovereignty of the people must be respected. And the sovereignty of the people cannot be respected, cannot be upheld where there is serious transgression at the wishes of the chairman of the Electoral Commission. Finally, my ladies, my lords, there needs to be a retribution. There needs to be a stop of all these transgressions. How many times shall we subject Kenyans to these processes? How many times should we appear before you with the same gravement every day, after every elections? There ought to be a stop. And a stop is making sure that the proper sanctions, criminal sanctions, as prescribed by the Election Act, are meted against any transgressor. And there is no one who is above the law, including the chairman, so that people may learn to respect the law. I'm so obliged. I donate the 26 minutes to the court.
Thank you very much.
Seconds.
Those are seconds. Thank you very much, Council. As regards petition number 7, we have Mr. Mtata appearing for himself, and Professor is appearing for the other. So I think you'll share the time, Prof.
Yes, thank you, Your Ladyship. Well, our submissions will be in two parts. The first part will be qualitative, and I will address myself to the law and complement the submissions that have been made by learned friend, Senior Counsel James Orengo, learned friend, Senior Counsel Philip Murgor and Feroz Noroji, on the questions of compliance with the law and on the unconstitutional nature and the non-compliant nature that the first respondent, Mr. Chebukati, employed in running the presidential election of 9th August 2022. My lords, the person I do not want to be now is Professor Githu Muigai, because every single advocate in this court has spoken to the violations by his client. Violations, my lords, that border on the violation and speak to the violation of Article 3.2, the unconstitutional proceedings that led to the issuance of Gazette Notice 9773 of 2022, issued on 16th August 2022, that declared the president-elect. My lords, we shall be asking that that violation or that Gazette Notice be vacated as we make several orders, my lords, under Section 84 of the Elections Act and Article 143 of the Constitution. My lords and my ladies, let me start by submitting that my submission shall be around one, the issues framed by the court, particularly, my lords, issue number 8 on illegalities and irregularities that, if applied disjunctively as this court has ordained before, my lords, will lead to a compelling order of nullification of the elections of 9th of August 2022. But I will also, my lords, and in view of the powers of this court under Section 3 of the Supreme Court Act, delve into the interpretation of Article 143. And my Lord, perhaps because this court is also the jurisprudential head of the judiciary, to see, my Lord, whether there are possible sanctions or possible findings that this court can make other than the order of nullification. And my Lord, that will be in my last submission. My Lord, let me just touch on the second part. The second part that my learned friend Mr. Omtata will deal with will be the maths, electoral maths, the mathematics of the election. We will demonstrate by way of a PowerPoint presentation that none of the candidates met the 50% plus one vote as per the tallies that were read by Chairman Chebukati on the percentages weighed against the voter turnout and the votes cast, my lords. And that will show that if indeed no candidate attained the 50% plus one, then this court has a daunting task. One, of course, after the exercise that is ongoing, the exercise that is going on with the server, my lords, we will be asking this court, my lord, to think of the possibility of declaring a winner after the outcome of the access to the back end of the server. That's number one. But number two, my lords, patently, the results announced by the chairman of the IEBC were unconstitutional because they did not emerge from the commission. And granted, my lord, that they were unconstitutional, if the court then is unable to arrive at a result as to who won the election, my lord, then of necessity the court would then would have no option but to proceed to nullify or find that it was conducted illegally. My lord, let me just proceed because of time to the key submissions. My lord, it is patent and glaring that there was non-compliance with Article 81A and D of the Constitution, read together with Article 86E of the Constitution. The elections were not verifiable inasmuch as voting took place. The process of tallying of the presidential vote from the polling station and the issuance of Forms 34As transmitted to the constituency tallying center and finally to the national tallying center, my lords, was not a verifiable process. My learned friend Philip Murgor has spoken largely to the access that two individuals had to the system. He had spoken of one Dahir and one Kwanusu who had access over 1,000 times Mr. Kwanusu, the PA to the chairman, Mr. Professor Githu's client. Clearly, my lords,
I would like to request the Honorable Court that we conduct this petition in the tradition, in the very long honored tradition of each counsel arguing in a sideshow.
My lord, it is a fact that the chairman is Professor Githu's client, but I will, because of the discomfort, address myself to the...
Yes, I'm speaking.
Yes, my lord.
I think you should treat your colleagues with respect. We all know that who is representing who. So make your point.
My lords, I will proceed. I will proceed. I will not mention Prof's name going forth. But my lords, the violation is glaring in view, my lord, of the fact that the non-verifiability of the process from the tallying center as held by the Court of Appeal, my lord, we've spoken to this severally, to the National Tallying Center of what each presidential candidate received, my lord, is a subject of an unconstitutional act. My lord, that is point number one. My lord, therefore, the counting, there was a violation of the duty to count each vote cast by an individual as contained in the Form 34A transmitted to the National Tallying Center and as uploaded to the Form 34Bs and 34C that was used to declare the result in Form 34D, my lords. My lords, granted further that violation is also reflected, my lord, in the violation of the Elections Act itself. Because, my lord, there was a requirement that once the tallying is done and the verification done under Article 138 3C, it was not the chairman but the commission that was required to undertake that process. And my lord, I want to speak to the affidavit of the chairman himself. Other advocates have submitted on the self-importance that the chairman presumed in conducting the final tally, ignoring the mandatory nature of Article 138 3C. This court has dealt with the question of interpretation of statutes and of the Constitution, my lord, where there's a compelling word, shall. Article 138 3C is compelling in nature. It does not give the chairman an option of consultation or of assuming the role of the commission. It states, my lord, that the commission shall undertake the process, not the chairman. The same term, my lord, is used in the second schedule to the IBC Act and in sections 4 and 8 of the Elections Act. My lord, if I may just read 138 3C. It provides, my lords, that the process of tallying, my lord, after counting the votes in the polling station, the independent electoral and unconstitutional shall tally. My lord, where shall is used before a verb, citing my learned friend, senior counsel, it leads to an inevitable and compelling option. And this is what the courts have interpreted in several cases that we have handed over to the court, my lords. The cases in Kirain Investments and National Land Commission, this was the finding of the court, again citing the findings of the Court of Appeal on the same question. Wesley, Judge of Appeal, laying down the consequence of the use of the word shall as peremptory. So, my lord, that of itself, any action reflected in the affidavit of Wafula Chebukati that denotes any action by himself in assigning other members work, my lord, and in eventually purporting to act under 138.10 alone without consultation invalidates the entire result that he purported to announce and invalidates the issuance of Form 34C and D in which he purported to announce the results of the election. My lord, ipso facto, the duty to transmit, tally, and collate was therefore violated. The regulations, my lord, 39(1)C of the Elections Act required two tallies, the physical tally and the electronic tally that ought to have been transmitted. Non-compliance, my lord, is evidenced in the affidavit filed by Cherere and by the 4 commissioners, my lord, and an admission by the chairman himself that the tally was not compliant with section 39(1)D of the Elections Act. My lord, going forth, the complementary nature of compliance reflected from sections 39 to section 44 uppercase A of the Elections Act, my lord, denotes non-compliance by the commission, but also an admission, my Lord, that there was no commission the moment the commission was divided and was working in different forms. My Lord, Article 3.2 of the Constitution provides that there shall be no government established other than through the Constitution, so that any violation that leads to an unlawful process, my Lord, cannot stand. And this court has the duty under Section 3 and Article 140 to invalidate an offensive action that is unconstitutional. My Lords, we submit that through the affidavits that admit the interference with the transmission system, the interference with verification, and the duty to declare the presidential election by the commission, the result gazetted in Gazette Notice issued by the chairman, being Gazette Notice 9773 of 2022, was unconstitutional and cannot stand and must be invalidated by this court. My Lord, in view of time, we wish to submit that even aside finding that even the duty of the commission as created and enshrined, my Lords, in Article 249, is governed and dictated by the principles under Article 10, my Lords. And my Lords, where public officers do not act in a manner donated by Article 10, then their actions must be vitiated by the court. And this is the forum where such actions must be vitiated. My Lords, the law is clear. The maxim exturpi causa non action, which has been developed over the years, my Lord, by Lord Mansfield, initially in Holtzman versus Johnson, later in Tinsley and Milligan, and now in Patel versus Mizra, speak to the fact that no circumstance can allow this action to stand. The opposing affidavits, my Lord, the opposing affidavits filed by the 4 commissioners and the 3 that speak to the violation of paragraphs 5 and 7 of Schedule 2 can only lead this court compellably, my Lord, to find that this is a matter that this court must handle in the manner that lex arbitri would dictate. My Lord, the principle, ex equo et bono, used by international tribunals to settle questions. In the local framework, my Lord, we refer to Solomonic wisdom in 1 Kings 14. The court should look at the opposing affidavits. The court should look at the misconduct of the chairman of the commission. The court will then compellably apply the dictates of fairness in this matter and find that the people of Kenya were violated by the conduct of an election outside the framework of the Constitution, through the violation of the process, through the violation of the outcome. And my Lord, we want to demonstrate to the court, before I wind up, that mathematically, and this is where the law meets mathematics, no candidate attained the 50%. If the chairman read the results that he read and the percentages that he read out of the registered voters that cast their votes, my Lord. My Lords, the maxim, amiable compositeur, that I shall look at after my learned friend, Mr. Omtata, presents the results, my Lord, will show you that this court has no option but to nullify this election. There's no option. There's no option. Mr. Omtata.
Gather because you're all senators, you're learning friends now?
Yes, my Lord, Mr. Omtata is a serial litigator and a public interest, a public defender in this country. And I respect him for that role, my lords.
And now a senator? And now he's a senator?
Yeah, he's a senator for Busia County. He replaced the Attorney General, who did not run for office.
Members of the Honorable Court, in my submissions, I will rely on the petition we filed jointly with the three others. It's dated 22nd of August. I also have submissions which I filed alone, which are dated 26th of August. And I also have a further affidavit which is dated the 29th of August. My lords, before I remark on the mathematics, I just wanted to make a small observation as regards point number 1. And I think the elephant in the room is point number 1. What kind of election does the Constitution of Kenya anticipate? That's a question that I've seen documents and videos by some members of the court telling me that even this court does not comprehend the kind of election anticipated under Article 81 and 86 of the Constitution. Short of a digital election, you cannot meet the constitutional threshold.
Mr. Mutata, what did you say?
I said I've come across publications and video recordings by some members of the bench who complain that the 14 days the court is given to determine a dispute concerning the presidential election is too short. And I'm saying that statement demonstrates the failure of, with due respect, the honorable judges of this court to understand the electoral architecture in the Constitution of Kenya 2010. The Constitution of Kenya 2010 only anticipates a digital election. And if we are dealing with a digital election, 14 days is too much. But if you are dealing with a paper election, a manual election, you need maybe 2 months. That's where I wanted to begin. And this election does not meet the threshold in the Constitution at all. The presidential election, the one I'm referring to, that's before this court. It's not simple. That's why you have got spoiled ballots. In a digital election, you don't have spoiled ballots or rejected ballots. And you don't even have the question of whether the spoiled or rejected ballots count. It's not verifiable. Right now, I cannot verify where the ballots I cast went. I don't know. The moment I dropped them in that box, I lost all contact with those ballots. There's no mechanism of verifying. A digital election would give me a serial number by which I could track my ballots. So I'm saying that if you look at the threshold in the Constitution, we must work towards a digital election and move away from these paper elections, which allow human interference without sometimes leaving footprints. I would now go to my submissions. I was supposed to be given some aid. Yes. Where is the...
If the time could stop running, we had supplied the electronic instruments to the court.
You guide the assistant.
Okay. I don't understand what you said. I come there. Oh, open for me the PowerPoint document. Go to the next slide. Yes, we're looking at an analysis of paragraph 26 of affidavit filed by Mr. Sunkuli in petition number 7, paragraph 26. And you can see that he's giving us, he gives data of how the KIMS kits transmitted on 9th August at 17 hours at the close of polls. He gives that figure. On 9th August at 20:45 hours, about some 3 hours and 45 minutes, he gives his figure of 13 million. Then, most surprisingly, you have two entries. There's the entry that which gives us at 14 hours and 14:40 hours. The KIMS kits are transmitting some 23 hours later, still transmitting data. And we're saying that that data is not acceptable. So we come to the next slide. I'll just run through given the short time I have. When you got that slide, you look, they tell you at 20:45 hours, on 9th August 2022, some 13,731,215 people voted. Polling turnout recorded on 10th August is 14,239,862 ballots. And on the 10th, that is the day after the voting, and we know that it's only elders where elections were taking place. Now, when you analyze that data, you find that 508,647 ballots are added on the 10th. And you saw Land Council Willis, you have recorded on the next day, you are talking of some 1,665,412 curiously cast votes, which are coming out after the close of voting, and that's after 3 hours after the close of voting. So if we take the total tally now, you find that the tally is close to it's about 1.7 million votes. That spike in votes is not possible. That spike in votes is part of the problems we're having, that fellows were having access, the KIMS kits that were still transmitting data from locations that are not clear. Because the KIMS kits that were in polling stations, the voting stopped on 9th. And giving an allowance of 3 hours or 4 hours for people who are still on the queue, you would understand by why Akim's kit would still be transmitting 23 hours after the close of elections is something that is difficult to comprehend. Also, my members of the Honorable Court, if you look at the Form 34C that has been published and interrogate the data there, if you look at the total of the variables ascribed to each candidate, the amount that you get is 110 votes less than the number that has been printed on that paper. Now, if you look at, that thing was boggling my mind. Initially, I thought it was a simple error of addition. But it has come out it was not a question of 1 + 1 = 3. Because when you look at paragraph 32 of the replying affidavit of Mr. Sunkuli, yes, I'm on, yes, go to the next slide. Next. Yes, sorry, I forgot to, thank you for directing me. If you look at paragraph 32 of the replying affidavit of Mr. Sunkuli, the total voter turnout in the table when you subtract from it, as given in the table, the number of rejected votes on Form 34, you get exactly that figure of 14,213,137, which in that replying affidavit they claim was an error of addition. But if you interrogate their raw data, you find that that figure is the valid figure. So the votes attributed to the candidates are fictitious. From paragraph 32 of Mr. Sunkuli's replying affidavit. So, when you go on to the next slide. I've reproduced I've tried to factor in the figure that Mr. Sunkuli gives, and when you add them, you get the 14,213,137. Yet, when you add the figures attributed to the individual candidates on Form 34C, they come to 14,213,027. That is not an innocent mistake. It is a situation whereby somebody has left a trail that they were working backwards from a certain figure which they had, and they were working backwards, and so they would going to get that. And most important, I would also refer to the affidavit signed by the chairman, filed by the chairman in petition number 5. At paragraph 95 of his replying affidavit, sworn on 26 August 2022, the chairman presents the exact figure of 14,213,137 as the total valid votes cast for all the 4 candidates. So if that is the figure that's coming from the raw data, that's the figure that's carried in the affidavits, then the values attributed to each one of the 4 candidates are fictitious and cannot count. And therefore, that Form 34C is an invalid document. Go to the next slide. Sorry, next. Yeah, so in that slide I'm saying, we can only conclude that these figures, which form the content of Form 34C, are cooked. You cannot have both of them in the same document. And this court should not allow that document to stand at all. And the conflicting figures, and those conflicting figures for valid votes cast of 14,213,137, and the other one is the one when you add the values of the individual candidates, the 4 candidates, you get 14,213,027, is evidence that the results were worked backwards to achieve a desired or predetermined outcome. Therefore, the declared percentages for the 4 candidates, no, the votes attributed to the 4 candidates and the declared and the percentages attributed to them is all fiction. Now, I go to address the question of whether you can achieve, if assuming that what in the totality of the announcements made by the chairman, any of the candidates realized 50% plus 1 vote.
Just checking on the time.
Yes. There's no display for the time, unfortunately.
According to mine, time is over. If you could just finish your slides.
Okay, thank you.
Because they seem to have lost theirs.
Okay, so a further analysis of Form 34C on voter turnout, the chairman announced, and that issue has not been retracted at the close of voting. He was answering a particular question, and a journalist asked him, as matters stand now, what is the national voter turnout? And he said, oh, that one, I can deal with it. And he said, as at the time he was announcing, it was 65.4%. And according to what the Kim's kids had reported. And he expected that value to go up when all the Kim's kids had reported and the manual had been included in it. So when you calculate that against the total voter register, the national voter register of 22,120,458 votes, you get that the voter turnout as at that time was 14,466,799 votes. The next slide. So from Form 34, the tallies are ascribed in Form 34. You get, when you factor in the rejected votes, you get a total value of 14 million.
Two, 3, 4, 5, 6, 7, 8, 9. Melala 100.
Hakuwa anapinga matokeo. Yeye alikuwa anasema tu, alikuwa anasema kuwa ule wakati ambapo matokeo yalikuwa yanatangazwa.
5, 6, 7, 8, 9.
Good morning, ladies and gentlemen. Welcome to the Supreme Court of Kenya for the hearing of presidential election petition number 5.
4, 5, 6, 7, 8, 9, 10. 120. 1, 2,
Confirm the counterfoils. We need to move to the next box as we agree on our notes on the forms. 225. Any contrary number? So 225 it is. The forms we record. What do you make of the forms? Let's have 2 comments. Yes, yes.
And therefore he decided to abandon the first one, which was not signed, and went to the other one.
So whatever happened for you, one form isn't signed, another is signed,
yes,
and even signed by them.
Yeah.
So we'll just note the 2. Yes. I don't know if there is. Do you have a different opinion for those who have seen that we have 2 forms, one unsigned, populated yes but unsigned, then one which is signed. So depending on what happened, we don't want to speculate, but we'll just have that in the report.
That is required under Article 138.4, 138, Clause 4, Paragraph A. And so, with those few remarks, I pray that the Honorable Court allows the petition and the other petitions, and then...
My Lord, I had intended to make the prayers in lieu of the jurisprudential weight of the mundane questions that I would want this court to answer.
Sorry, Senior Counsel. Can Mr. Omutata confirm? I'm trying to go through the record. This PowerPoint presentation you've just made, is it part of your pleadings?
Yeah, it is it's part of my pleadings in a law.
Word for word?
Yes, word for word. But I'm just cutting for purpose of highlighting.
Okay, thank you. Unless you are changing, that is not word for word.
No.
So if it's word for word, we don't need any other copy.
But of the most important is the father affidavit. Because when I did the first one, I did the petition, I did not have the information that came from... I did not have the information that came from Mr. Sunguli's affidavit. So I would request the court to pay particular attention to the father affidavit. That's why I had the benefit to compute the figures with the figures that the commission supplied. That's all, my lord.
Thank you.
Compelling are the figures that finally mathematics finds its way into invalidating.
So, General, you have no leave to address the court after time. Why don't you start from there?
Just from the press.
From where? From what time?
Leave from the bench.
Start from there.
Your Lordship, may I seek leave? Just make prayers.
Senior Counsel, we agreed on the ground rules yesterday. Your time is up. In fact, his time went over because he was on the PowerPoint. We noted he went over by 6 minutes. So please, yes, if you have anything, you can reply when you have time to reply. Rejoinder. I will now invite counsel in petition number 6, Julia Yokabichege and others.
May it please, Madam Chief Justice, Deputy Chief Justice, and other members of the court. My name is Kibe Mongai, appearing with Ms. Wairi Mokeru for Julia Nyokafishege and 3 others. First of all, let me say that I'm very happy to be responding last and particularly to have had that very good presentation by my long-term friend, Mr. Okiya Omtata. My Lord and my ladies, the petition before the court has been introduced. The petition is dated 22nd of August this year. It is supported by two affidavits, an affidavit sworn on 22nd of August by Julia Shege, and a further affidavit that she swore on 28th of August, 2022. We have done submissions which were filed on the 30th of August 2022. That is when they were stamped. And we have also done a bundle of authorities as required. Now, having introduced the pleadings that we have filed, I wish to, looks like I don't have the petition, but basically the petition before the court, the petitioners are basically arguing for invalidation on the simple ground that there were so many violations of the constitutions and the electoral law by IEBC and its chairman, as the case may be, and as a result of which, those violations constitute such severe illegalities and irregularities that the results announced ought to be nullified. We have pointed out, for purposes of the specific issues raised by the court, we want to dwell with issues number 6 to 9 that were identified by the court. And to sum up, because before we go to the exact issues, is we shall basically be talking about 3 violations before we refer to the conclusion. Now, the first issue is the fact that over 700,000 people who ought to have voted during the general election held on 9th of August were deprived of the opportunity to do so. Number 2, we shall be arguing that the third respondent, that is the Commission, contravened or violated its duty of accountability, transparency, and public participation during the 4 stages that we shall shortly be outlining, and in a manner that it declared the results of the presidential election. The third issue that we shall be referring to is the fact that the third and fourth respondents violated the procedure set out in Article 138 of the Constitution in discharging their mandate of tallying and verifying the vote at the Bomas of Kenya. I start with issue number 1. The constitutional basis for issue number 1 is Article 38 and 138A of the Constitution. And in this, we are referring to the number of people, 700,000 by our count, who ought to have voted and were deprived of the opportunity to vote. Now, what is a complaint? The complaint, members of the court, is laid out at paragraphs 56 to 60 of the petition, paragraphs 56 to 60 of the Constitution. And the supporting evidence is laid out in paragraphs 24 to 28 of the supporting affidavit sworn on 22nd of August, 2022. The long and short of those paragraphs is that the petitioners are basically saying that by virtue of Article 1 of the Constitution, the people's sovereignty is exercised in Kenya by 2 major methods: through voting, and collectively we only exercise that right during a presidential elections. And number 2, by voting in a referendum. Now, under Article 38, it is expected that the right to vote for a candidate of your choice is recognized. The same way under Article 138(3)(a) of the Constitution, voting at a place appointed by the IEBC by all persons eligible to vote. Now, on that basis, Regulation 90 of the Elections General Regulations Act, General Regulations 2012, were done under the Elections Act. Regulations 90 provides, is a short provision that I need to read, that the Commission may make provisions for the voting by election officials, observers, patients admitted in hospital, older members of the societies, members of the defense and security forces on duty, prisoners and nomadic pastoralists, and other persons who by reasons of any special need, including disability, are unable to access a polling station. 2, the Commission may from time to time publish notices on the manner and procedure of the conduct of special voting, and such notices shall be read as part of these regulations. So the long and short of it, but I want to tie up with the facts, in paragraphs 50, the petitioner says no such notices were issued with regard to the persons in contentions in this particular contest. Who are those persons? Those persons include at least 500,000 elections officials. They include at least 180,000 members of the security forces. It includes those people who are in hospitals and others who may not be in hospital. But they are placed in such circumstances that special arrangements ought to have been done to ensure that they were able to exercise their rights under Article 1 and Article 38 of the Constitution. Now, why have we chosen the figure 700? The figure 700, as you will see from the affidavit, has been chosen for the simple reason that there should be no contentions about it. These figures, these are elections officials. The IBC chairman is quoted in the newspaper report that is attached to that affidavit, in fact confirming that indeed all this number of peoples will be engaged during the election day. Their engagement during the elections day follows up of necessity and in the nature of their duty that starts at earlier than 6 a.m. and ends long past the counting period, that those are the people envisaged under Regulation 90, that special arrangements to ensure that they vote would be made. It is not denied, in the face of these complaints being made, that those arrangements, in fact, were not made by the Commission. Now, it is important to point out these regulations were made in the year 2012. Of course, it is interesting to know, faced by these complaints, how did Chebukati answer them? He answered them in his affidavit by first of all saying prisoners were allowed to vote under Regulations 90. He says diaspora Kenyans were allowed to vote under Regulation 90. And he also says very old people and sick people would be first on queue, and so such instructions were issued to ensure that those kind of people would vote first with a little bit more convenience than others. But, Your Lordships, it is important to note that when it comes, for example, that prisoners voted, prisoners have been voting in Kenya in the presidential elections, not so much because IEBC has been complying with the law, but because I believe it was Judge Lenaola, when he was at the High Court, made an order first that prisoners to vote in the presidential elections, and number 2, in the referendum. And that was done. Even the reasons why diaspora voters vote in Kenya is again because of another subsequent court decision. So that where we stand today, for purposes of Regulation 90, IEBC cannot give a single instance that in support of ensuring that as many Kenyans as possible will vote for the presidents of Kenya and exercise their rights to franchise has ever done anything. There is no evidence of that. Now, during the preparation of this petition and afterwards, for purposes of these kinds of violations, the right to franchise, it is a very serious thing across the world, because as many of us are entitled, and that is why even this right was given to prisoners, to ensure that we vote. You find in very many other countries where elections have been nullified because of the issue of franchise. But you do not have a single instance, at least to the best of my knowledge, that this has ever happened in Kenya. And this could probably explain why, even after the Constitution is clear on this issue, that facilitations be made to ensure as many people as possible, and those in special circumstances, those arrangements have never been done by IEBC. It is my submissions that, given the results that were declared on the 15th of August this year, voting by up to 700,000 voters, even if that was adjusted, how many of them could have been registered and how many of them could actually have voted to the actual averages, you would still have arrived at a very big figure of more than 300,000. That directly, and on account of non-compliance with an express provision of the law, were unable to vote. Did the failure to make that accommodation, those arrangements, to ensure those people voted affect the results of the elections? Undeniably. If those people had voted, it is our submissions that the results of the elections could have been affected. And my Lord, it's in my submissions that unless and until this honorable court take up that issue as a serious issue of violations of constitutional law, then Regulation 90 could as well be an empty piece of legislation. And therefore, part of the enforcement of ensuring that the universality, that the free franchise and universality of it is respected, would be to ensure that a very serious elections was violated on its account. And it is on that reason that when we read our submissions, we are urging the court to do exactly that. Issue number 2 has got everything to do with the fact that the duty of accountability and verification, as we had said, was violated at various stages. It is my submissions that there are at least 4 stages in which this happened. Number 1, stage 1 ordinarily occurs the stage between 20th, the election period. A gazette notice was issued on 20th of January to signify the commencement of the election period. That period ended on the 8th of August. Then there is stage 2, voting day. Then there is stage 3, which is a 7 days period under the procedure set out under Article 138 of the Constitution. Stage 4, in my submission for purposes of the presidential election, it is the 21 days period under Article 40 of the Constitutions that you are dealing with right now. Now, what are the stages at stage 1? The issues at stage 1, and I will link them up with how they tie to the elections, is the fact that in this particular case, IEBC, according to my clients, was supposed to ensure that they set up a technology system that was transparent enough to ensure that the outcome would have credibility in the eyes of the electorate. The one single issue that we have pointed out for purposes of that in an elections where you've said you have recognized voters using KIMS kit, it has been recorded, it is our submissions, that on day 1, in their affidavit, they say 6 hours, that at least 6 hours after the conclusions of voting, Kenyans ought to have known what many people voted electronically and using any other complementary system of voting. And my lords, it is my submission that the failure to do that, one cannot be able to speak of a technology that worked if the most important component that a voter ought to know, the right of a voter to know, yes, we voted. If we reach this number, this man is president. If we reach this number, this one is president or is in the opposition. That number ought to have been given without any dispute. There should be no controversy about it. Yet the fact that you have all these controversies about the register just points out to the issue that on that critical element, there was serious failure of that technology. But it may not necessarily have to be a serious failure of the technology, in the sense that it could well be that the manner in which now you conclude voting, Forms 34A were uploaded, but the actual figures were being named on day 2. This is day 2 after the arrival of all Forms 34A. It is our submissions and my hypothesis that any person, and nowadays there are so many books that you can read anywhere and you can buy anywhere, that says, how do you rig elections? If one were set out to rig an election such as this one, then one of the most important variables would be the voters' register. And in this case, it is our submission that the fact that on day 1, 6 hours after the election, we were not told in a controversial manner, and after Kenyans have invested in a technology, that this number of people voted, this opened the system in the subsequent verification process to the kind of abuse that more other able people in that area have spoken about today. But that, on the face of it, appears to be where the opportunity arose. I go to the issue of still at stage 1, the issues of the nomination. We have said in our affidavit that for purposes of Article 99 of the Constitution, the presidential candidates were supposed to be subjected to qualifications under Article 99. The manner in which that was done for purposes of presidential election, the second respondent was actually not subjected to it, and at the end of the day, persons with unresolved questions under Chapter 6 is today Deputy-elect of the Republic of Kenya, arising out of the failure of IEBC to enforce the law. The next issue is the publication of a Gazette Notice number 9540 on 8th of August. This Gazette Notice in our submissions was an instrument of illegality. My learned colleague, Mr. Nyambodi, says that IBC chairman is always inclined to produce Gazette notices even where none is required. I read it differently. If you read Gazette notice as an instruction manual, it makes a lot of sense. In this sense, that in the ordinary scheme of things, and particularly when I was working in the human rights movement, when you deal with a lot of police officers and other people on those junior ranks, this activity will be carried this way. They'll not tell you the Penal Code says this, the Police Act says this. They will tell you the forces standing order, which they are socialized to understand, says this. So this was the forces standing orders. So that for purposes of the day when this verification was being carried out under this, what we are calling stage 2, it was being, and it was published on the eve of the election. There was also the bad faith that on the eve of the elections, you publish such kind of a Gazette notice that runs directly counter to the Constitution. Why would anybody do that in good faith? There was lack of good faith. Because in the Republic of Kenya, during my practice of a couple of years in public law, we are aware this is the kind of stuff that we present in Constitutional Division and the Judicial Review Court to confirm whether or not it complies with the constitutions or statute. Therefore, when you publish such a Gazette notice, an instruction manual that would be deployed during the verification exercise, and the following day is a public holiday, you cannot be taken to have been done that with the best of intentions. We got to stage 2, voting day. Voting day, the first violations that we talked about, not everybody entitled to vote under Article 138 in the presidential elections actually voted on account of non-compliance with the law by the IEBC. The second issue for purposes of that day, I've already talked about it, is a voters register. That on the elections day, and we have said 6 hours, you needed to know how many of us voted. The moment that information was not provided, the system and the process was exposed to anything could happen. And actually by the 15th of August, the worst, and all that could go wrong actually went wrong on the 15th of August. And therefore, this is why we are saying these violations were not just minor violations. They were violations that indeed went into the heart of what is before this court, the disputed elections. At stage 3 is what we call the procedure under Article 138. Well, my constitutional law mentor, Dr. Gibson Kamau always used to tell me, and I believe most of the people who had the privilege to be his pupils, that the Constitution must be understood in a historical context. And therefore, it is important that we understand Article 138 in a historical context. What is this context? This context, my lords, is this, that we do not have an equivalent of Article 138. We do 6 elections. The Constitution has not told you this is a procedure at the parliamentary elections or the governor or anybody else. It is only reserved for one position, the president position. The procedure at the presidential elections. And this was to leave no room of doubt that this is how in which the verification process ought to be carried about. My lords, the process after we vote in a presidential elections, I first voted in 1992. And since that year, the first multi-party elections, after voting, of course in Kenya they tell you, vote, go home, watch it on television. You will get to know the outcome. How it has always worked is that you are there at home, results are read from constituencies, from everywhere else across the country. It is a ritual that happens every year as far as I can remember since the year 1992. Now, what is the importance of this ritual? It is important to remember that in the year 2007, this ritual was disrupted by the events that happened at KICC. The disruptions of this ritual led to the post-elections violence, and the rest of it we are all aware what happened after that. So that it is not a simple ritual. And so that in the year 2010, when the Constitution was written, it provided for a sections and 7 days and a procedure, setting out in no uncertain terms, this is how after people vote for their president, we are going to process the issues. So that the Constitution having dealt with that issue against that historical background, you cannot have a situation where subversion through a gazette notice is tried to be effected. That would be treason in every sense of the word. I go to the issue of what's the importance of the ritual. To the winner of an election, this ritual that we saw in this constituency, what you got in my neighborhood is very important. Because the people, while we are seeing all this being displayed, and remember that during bombers, the display to show Kenyans that these are the results that were coming in, this is how the figures were adding up, that was disabled at some stage. So that what effectively this meant, that the true purpose of Article 138 ends up being defeated. Defeated in the sense that for the winner goes and declares that I had the most numbers in accordance to Chebukati. And the loser, everybody else says, I do not know how you got those numbers. I actually thought I had more than you had. This is what was tried to be prevented. But it is equally important the procedure under Article 138 for the loser. Why is it important for the loser? Because the loser, and in this case the loser is a loser with say about 6.9 million votes, quite a number of Kenyans. This is a loser on his 5th time seeking the presidency. The last one he says he lost under controversial circumstances. There was everything necessary to ensure that for purposes of these elections, if you are to lose the election, the math must make sense. It must add up. The Kenyans, those people who voted for you, must also see that you did not do very well, because it is clear these people in that other place did not vote for you as you expected. Now, but when you have now a true situation on the 15th, the dramatic events of the 15th of August, where even 27th constituency, my clients are there waiting at home. I was also equally waiting at home. Those results are not announced. Then how do the people who are supposed to be losers understand that they genuinely lost in the elections? That would strip the process of legitimacy. But it is equally important for another reason that Wallace Soyinka talks about in one of his essays. And I believe the essay is published in a book called Climate of Fear. And Wallace Soyinka, in an essay titled The Quest for Human Dignity, says that in war, it is important that those who lose a war should not be stripped of their dignity. And basically what this means is this, that even after losing war, you are not stripped naked in the sense that you are told you lost half of your country, but you must be left with the other half. That is if you are in the Russia-Ukrainian kind of situation. That is a whole idea that nobody should lose absolutely. And when the Constitution talks about fairness, about transparency, it is to enable that this is processed in a manner that everybody else would be able to understand and to process the victory or to process the loss, if it turns out that it was a loss. Now, we go to the issue number 4. I wish I could say more. I'm just trying to watch myself. Stage number 4, the final issue is the Supreme Court issue. We served Chebukati with our affidavit. And I would not say he's arrogant, because that may not be a permitted language. But the language that he used is one that shows lack of remorse. You will read the affidavit. On the issue of, why didn't you make arrangements for everybody to vote? We were talking about specific people, election officials. Then he says, oh, prisoners voted, diaspora's people voted, and all these other people voted. Now, that was not the issue. I think they are needed, and this is accountability to the Supreme Court. And that is the design of the Constitution. That now that a violation has been committed, what do you have to tell the court about it? You could not even say it was an oversight. The next one I will recommend to the next chair to ensure it is done. There was no such thing. Then we go to the next issue. In our affidavit, the third petitioner says, I was disturbed about the events of 15th because in the morning of 15th at around 7:30 a.m., I was shown some text that seemed to show the results that now are being announced later. Why was it disturbed? Because at that time, votes were still being counted. People are being told in constituency A, this is what people got. How does Chebukati react to that? Oh, everybody with a good calculator could have downloaded these forms 34A and calculated. Now, Kenya is a country with extremely low digital literacy. To say, and when such a thing that would cause concern, that there was a problem, and you say this information was readily available, leaves a lot to be desired on the part of a public officer. I start with finishing with the issue of legitimacy. It is important that winners should have legitimacy. And it is also important that the losers also should be treated with dignity. When we read the affidavit of Honorable William Ruto, he says, oh, so many people, why are you pretending that you are acting for all Kenyans? So many people agree with my victory. But it is also equally true, so many other Kenyans don't agree with it. And therefore, in a constitutional democracy, as I conclude, it is absolutely important that when you win, and Article 38 says you win it this way, it must be confirmed. Thank you very much.
Thank you very much, Council. We would like to take the submissions by, I think, 4 respondents who are supporting the petition. That is the 4 commissioners. According to the time schedule we allocated yesterday, they were to share the 1 hour. But before Council, you take the podium, we are proposing just a 15 minutes health break. Then we come back because we will hear those submissions. And if there are questions from the bench to all the submissions that have been made, they will be directed to Council. So we'll need about 1.5 hours when we return to finish today's proceedings.
Taya, on the word from Justice Lenola, could the court find out what's happening to the question of scrutiny? Because it looks like we still have a crisis.
Yes, we shall. I'm aware.
Minwa, Agal Toto, Abebo. It's been a while, but you're looking so fine. And let me ask, have you eaten? Have you taken lunch? Don't punish yourself. Let me wire something kidogo kwa simu. Is 70,000 enough? Hii weather iko na baridi hawa. Should I book some hotel in Diani or Zanzi? And let me ask you, will you use chopper, business class, or first class?
Dial *811*447# to get a Toti Jaber.
Processed foods can contain high amounts of salt and contribute to increased bloating.
Petal Care has a floating design that perfectly fits. It reduces 70% friction on skin, absorbs fully, and blocks leakages from both sides. Soft Care, yeah.
Are you ready? Let's go. You're going out tonight.
Japo tuna tofauti,
kila moja wetu ana sauti.
Nubasan Adambane No Adambo Soreti Mata Sore Telpani Abusa Kabay Sekani Sekani Kangaroo Mubata Jarai Yadida harkota kiri Ogalahetia Urra baranda tabe Urmate jalatane Ogalahetia Sulul taloni tikso Darabati gachi Ogalahetia Yoman ufesi akka Ansirra fadon jirai Madan jira madan Jira madan jira yaga Madan jira cacap senaya jira Adin jiru yaga Adin jiru Utenanya Kote nami Sisani darbate yaga Kote nami Sisani darbate Kafem bulu nami Bangkate yaga Madan jira cacap senaya jira Buddhaleen kan tufaan algaloota gaara bichuu turiin algaloota dalaan finfinnee algaloota silaakka jaalalaan algaloota walirraan fagaannuun algaloota jalannoo fagee algaloota buddhaleen kan tufaan algaloota gaara bichuu turiin algaloota dalaan finfinnee algaloota silaakka jaalalaan walirraan fagaannuun algaloota jalannoo fageessa diigamee gaara sanaa gaara diigamuu malee nu baasan addaan baanee nu addaan ba'uu malee sooretti haadha soolee irbaanii rabuusa qabay seeqanii sesseeqanii kan gargaar nu baatan jarayin Farda sidaa kabani sidaa dabale suuri Ogalahetia Irkaan udaan keessanii barri ture duuture Ogalahetia Waddeessi jiraa gube amborraa janakkiisi Ogalahetia narraa fagaatte jedhe siyaadin kiyya yoo malle Mada nafe mada nafe aga Dane mada nafe cacabse nana delave Adin jiru ane adin jiru yaga Adin jiru kukute nana dele Tuwa jeti Rona kani yaga Tuwa jeti Rona kani Namagaran ane Namunar kani yaga Madan jira cacabse nana dele Madan jira madan jira
Oyon Superboy Junior Enyanduli Mulimbo chera karwa mugondo Kanyora mukae ni karigete Akairundi agasoa irongo Elianyori bukata bisete Insasa bayara seretio Matanga
PR 006399099. Those are the 4 batches. We set them aside. So we go to unused ballot papers, first serial number, PR 0063884.
All right, so we will move from there. That's for the House where the scrutiny and retallying of 15 polling stations is going on. And to be more specific, this is a scrutiny of 45 presidential election ballot boxes from 15 polling stations that kicked off this morning. And this was part of 5 orders given by the Supreme Court yesterday that would have been adhered to. And of course, this exercise undertaken under the supervision of the IEBC and Supreme Court Registrar. The lawyers for the IEBC, Chairman Wafula Chebukati, Commissioners Raila Odinga and William Ruto are also present to witness this particular exercise. So once again, the tallying, scrutinizing of ballot boxes from Vita constituency, Mombasa County, of course, underway right now at Forodha House. This happening simultaneously with the proceedings at the Supreme Court, where the 7-judge bench led by the Chief Justice Martha Koome are hearing submissions from various petitioners. If you can remember, 7 petitions were consolidated into one. This was because several of the issues that they raised overlapped. And so the Supreme Court going ahead to hear those matters throughout the day. They are currently on a brief health break, should be back in about 3 minutes or so to continue on. According to the Chief Justice Martha Koome, they should take another hour, 30 minutes to hear from the other submissions. But let's listen into Forodha House.
Yes, because it's stuck here, but it's a counterfoil.
Okay.
What's the serial number?
Check the serial number again.
PR 00638844.
So if whether it's first, second, third, or the one that has 445, this should be the first one on the 45.
Okay, rejected votes. Rejected votes. Okay. Rejected votes. The first one, 1 and 2. 2 rejected votes. Used seals. We have 4. So we are going to valid votes. Valid votes we have 1, 2, 3, 4, 5, 6. We have 6 rolls. So we'll proceed to as pattern. We just we have the shower. So it's very hard to know, huh?
So please note what is happening here. These rolls, because they are all together, they have to open and then check each roll.
Yeah.
So we noted that they were not in the seals, in the polythene.
Sorry? We just count. Oh, okay. So just say batch 1. We open them. It's good.
Yes. Yeah.
So we open all. Let's open all. Just 1 minute. Pick 1.
1, I think deal with that, isn't it?
Not enough.
Yeah. So, Honorable Were, what you have, just tell us they are in respect to who, in favor of who?
This one is in respect to William Samoei Ruto.
You have confirmed?
Yes.
Yeah, ziweke hizo. So you are holding those ones?
William Samoei Ruto. So that's the second batch.
Give them to Were.
This is for Raila Odinga.
Okay, give them to, you receive them.
This is William Samoei Ruto. Raila Odinga.
So you have them?
Raila Odinga.
Raila is here, yeah.
We have George Wajakoya.
Weka katikati. So let's start with the one.
This one?
Yeah.
This one, yeah.
No, it's okay. Just tell us if it's we have confirmed. We can start counting those ones. Please count.
You pick on the thing. You pick on the thing.
Yeah.
Okay, we are counting Wajakoya. We are counting George Wajakoya. One.
That's Raila.
No, it's not one. Two, George Wajakoya. Three. Four. George Wajakoya, total 4. So kuje Lundu. Oh, sorry. Okay. For David Wahiga, we just have the tallying sheet, so there is no ballot cast on his favor.
Okay, so let's start. Yeah.
Okay. We're starting with the batch for William Samoei Ruto. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50. Those are 50.
All right, we interrupt that scrutiny and retallying of ballot papers from 15 polling stations at Forodha House and take you now to the Supreme Court. They were on a brief health break and returning now. We can see the 7-judge bench making their way up to the podium. As mentioned by the Chief Justice, Martha Koome, they seek to take another hour, 30 minutes to conclude today's proceedings and other matters that may arise from the submissions that will be made within this next hour. That includes questions from the 7-judge bench as well. So let us now listen in to the proceedings as they reconvene.
Yes, good evening. Just before you take the podium, I think we needed to clarify something arising from the scrutiny. Justice Renaura will do so.
The Chief Justice, Counsel, the two processes are going on well, both at Forodha House and at IBC. Whatever issues are being raised by parties are being addressed by the two teams. I suggest we let them proceed, and then again we can revisit any arising issues tomorrow morning. But so far, both our teams are saying the process is ongoing. We should not trouble ourselves for now. Thank you very much, CJ. Thank you, Counsel.
Yes. Okay.
Chief Justice, Deputy Chief Justice, Your Ladyship, my Lords, Justices of the Supreme Court, my address will be followed by Apollo Boya, who acts for Cherera, the Vice Chair, followed by Jotham Arua, who acts for Commissioner Justice Nyangaya. He'll be followed by Jeremy Jenga, who acts for Commissioner Francis Wanderi, followed by Gordon Ogola, who acts for Commissioner Irene Masit, and then finally Mansu Issa, who will address the court on behalf of the 4 commissioners collectively, as I will be addressing this honorable court on behalf of the 4 commissioners collectively.
So are we giving each one of you 10 minutes? Or within the 1 hour? So we put there 1 hour?
Yes, we'll distribute amongst ourselves. Yes. We hope to do it within that 1 hour. Your Ladyship, my Lords, the first submission, fundamental submission I'd like to make is that when this honorable court retires to consider the judgment it will deliver, this court be guided by the fact that it is the position taken in this court by the 4 commissioners, being a majority of the IEBC, that should inform this court's decision, not the views of the minority. The official position of the Commission is as per the views an affidavit of a majority of the commissioners. And that has to be so in law. The reason being that under the Constitution, and in fact under the statute, the IEBC is a corporate entity. Therefore, in the absence of consensus, its decisions as an institution are by the majority. So do not depart from that principle, a principle that has found judicial anchorage and recognition in a number of decisions cited by my colleague Paul Mwangi, the minor KI decision, the Michael Kamau case, and the other decisions. Corporate decision, and that position has been addressed, and I do not want to take the time of the court by going through it again. With regard to each one of these four commissioners, I ask this honorable court to bear in mind that each one of them went through a very rigorous vetting by the National Assembly, at which there was full public participation before they got appointed, so that anyone who had any issue with any of them, that was the time to raise the issues. Again, the law is clear about how one can complain about a commissioner enjoying constitutional security of tenure. So do not be influenced with innuendos and insinuations about these four commissioners. They were vetted by the people's elected representatives. Now, coming specifically, this is the second fundamental submission I'd like to make. This so-called walking out from bombers. Look at the affidavits of the four commissioners. The vice chair saw 2 affidavits, so there are 5 affidavits in total. And I invite this honorable court, when it retires, to read through those affidavits in their entirety. We adopt them. We rely wholly on the averment in those affidavits. And you will find in those affidavits that all that these 4 commissioners were demanding of the chair at bombers at the tail end of the tallying and the verification. Their narrative, which I invite this court to accept, is that they were not involved in the tallying and verification, and in particular regarding the 27 constituencies. So they were demanding of their chair, you cannot bring a paper here and tell us that these have been verified and tallied by the chief executive. The work of the chief executive is to implement decisions of the commission. He is not part of the commission, any more than the registrar, the chief registrar, implements, or any registrar of the High Court, implements the decision of the judges, not the other way around. So they were saying, we need to tally and verify the results in respect of these 27 constituencies. And the chair would not allow that, which was typical of the relationship between the chair and these 4 commissioners. And a twist is being given that it is these 4 commissioners that wanted to force a runoff. It is the exact opposite, your leaderships and my lords, and that is what we state in the affidavits. It is them who were asking, how do we confirm that the candidate you are about to announce has received 50 plus 1 votes? And his response was, are you trying to force a runoff? I am not conducting another election. So this acrimonious relationship is what was there between the chair and his two allied commissioners and the other 4 commissioners. Now, I would like to submit that the 4 commissioners were fully justified in saying we cannot own results we have not tallied and we have not verified. The law has been referred to this honorable court severally that it is the commission that should do the verification and the tallying. This legal notice that appointed the chair as the returning officer, you've been invited to hold that legal notice, that regulation is unconstitutional and valid because it contradicts the Constitution and the Elections Act. But beyond that, it is the chair himself alone who appointed himself as the returning officer for the presidential elections. You will not find any minutes of any meeting by the commission appointing the returning officer. So quite apart from the fact that it was unconstitutional, it did not have the authority of the commission. I would like to cede ground to my colleague Apollo so that we operate within the 60 minutes accorded to us. I ask that this court uphold the position of the 4 commissioners, that the results that were announced were not the results tallied and verified by the commission. I thank you.
The Chief Justice and members of the court, without wasting more time, I'll pick it up from where the senior counsel has left. My name is Apollo Mboya. I am on record for the fifth respondent. Your Ladyship and my lords, the actions of the chairman of the Electoral Commission can be evaluated using several instruments. And I believe the first instrument that we need to use in examining the whole issues that are before this court is the oath that the commissioners take. The oath is in the 3rd schedule of the IEBC Act, so that for every action, we juxtapose that oath to those actions so that we test if the actions meet the tenets of that oath. And permit me to read what that oath says, and it's taken by all the commissioners. It states, I, then they say their name, having been appointed chairperson or member, as it can be, of the Independent Electoral and Boundaries Commission, do solemnly swear that I will at all times obey, respect, and uphold the Constitution of Kenya and all other laws of the Republic of Kenya. That is the oath they take. That I will faithfully and fully, impartially, and to the best of my ability, discharge that trust and perform the functions and exercise the powers devolving upon me by virtue of the appointment without fear, favor, bias, affection, ill will, or prejudice. That is the promise that they are giving to the people of Kenya and to the whole world. Now, for every action that the chairman did, which I'll not go into because this particular affidavit of the 5th respondent has been cross-referenced by my other senior counsel and also learned colleagues who spoke before me, we juxtapose those actions against that oath that they took. So, for example, if we are talking about issuing a gazette notice, you look at that gazette notice with the law, then juxtapose it to the oath, if it meets that promise that they gave. Your Ladyship and my Lords, the fifth respondent is now affectionately called opaque. Affectionately. I say that because arising out of what transpired at the National Tallying Center, the four issued a statement in which they said they cannot own the results that were going to be announced by the chairman, and therefore they were opaque. Your Ladyship and my Lords, that term opaque is not coming from the ordinary. It's a term that was given by the Court of Appeal when they were making a decision in another matter, which is now famous here, called the Maina Kiai matter, which when they were looking at the role of the chairman vis-a-vis the other commissioners. And the court did indicate that to suggest that one individual alone can tally and verify the votes for presidential election is to suggest otherwise, to introduce opaqueness and arbitrariness to the electoral process. Those were the words of that court. Members of the court, we might ask if the chairman has indicated from the affidavits that we have had that it was his responsibility alone to tally and verify the results. Then the question is, what were the other commissioners supposed to be doing on that election day? Were they supposed to sit at home and watch the screens just like any other Kenyans? But then again, the chairman went ahead and allocated them duties. With respect to the fifth respondent was given the role of media. In that role, the fifth respondent was supposed to explain even to the media why what they were reading, the results they were reading, are not being projected on the screens. The results that they read were not projected from Friday 13th. And when that question was put to the chairman to refresh, the chairman said, no, I'm tallying from the back end. Your Ladyship and my Lords, the sum total of this whole transaction is that the chairman usurped the powers of the commission. And it's our submission that after all is said and done, and after we get the reports of the verification, I believe that this court will arrive at a conclusion that the chairman of the Electoral Commission was actually an agent of a presidential candidate. That presidential candidate we will know by 5th of September. And if that's going to be the case, lastly, it's our submission that this court must go further and look at the theory of agency. All the conspirators that did any illegalities, all irregularities, are agents of one another. The person who benefited from those irregularities and illegalities is a co-conspirator with the persons who perpetrated it, and they are agents of one another. And for that reason, we would urge that this court makes appropriate decision with that particular issue in mind. I call upon my learned colleague, Jotha Marua, to take over from me. Thank you very much.
The Honorable Chief Justice and the honorable members of the court, my name is Jotham Arua. I appear for the 7th respondent, Commissioner Justice Nyang'aya. I will be making submissions on the following issues. Issue number 2, whether there was interference with the uploading and transmission of Form 34As. I'll also speak to the issue whether there were irregularities and whether the irregularities affected the results. I'll mention briefly something to do with the reliefs that this court ought to make, and also issue number 6, whether IBC carried out the verification exercise. So on the first issue, my lady and the honorable members of the court, the position of my client is that there were indeed interference with the uploading and transmission of Form 34As. My client maintains that this was done without the involvement of the commissioners, specifically the 4 commissioners. And it is their position, my lady and the honorable members, that it was done in clear violation of Article 81E of the Constitution and Article 86. Before I proceed, I wish to clarify that we have made reference to a number of authorities in our written submissions, but I will not refer to them because of time constraints. As regards interference with the ICT infrastructure, the Commissioner, in his affidavit, which has been filed before this court, and specifically in paragraphs 33 to 34, raises a number of issues. First, he maintains, my lady and the honorable members, that the server was accessed by unauthorized persons, and these included foreigners and some members of the IEBC. He mentions them by name. He further maintains that one foreigner by the name Gudino Omar accessed the server several times. He explains that a number of forms were pulled down and others uploaded. And he also maintains that there was revision of Form 34Bs. My lady and the honorable members, these allegations are contained in his affidavit, and I wish to point out that they have been responded to by IEBC. In their response, the first thing I wish to point out is that there is no denial that the logs that he annexed to his affidavit emanated from IEBC. The only contention being raised is how did he get them? That contention, in our humble submission, has no merit, considering, as he puts in his affidavit, that he was the commissioner in charge of ICT at the commission. If a commissioner who is in charge of ICT cannot access that kind of information, it is my submission that nobody else in IEBC can access them. The next thing that, and that admission, Madam Chief Justice and the honorable members, is found in the affidavit of Hilda Kavonga. That affidavit is filed by the firm of Iseme Kamau and Maema advocates and is sworn on 27th of August 2022. And the admission is contained in paragraph 13, Roman 4. Beyond that, Madam Chief Justice and the honorable members, there is also an admission, and this, according to me, is a serious admission. There is an admission that the server was accessed by a foreigner by the name Gudino Omar, as mentioned in the affidavit of Justice Nyang'aya. But I wish to read to the court what is said as concerns this foreigner. At page 5, paragraph 13.7 of her affidavit, that is Hilda Kavonga, she says, Gudino Omar is the technical lead for Smartmatic, who provides support on the technology provided by Smartmatic. He's the technical deployment lead, and then in paragraph 8, she continues, they said Gudino Omar, being a technical deployment lead, his role is to deploy infrastructure, that is networks, server platforms, and services. In his capacity, he is supposed to have access to the said infrastructure to monitor by ensuring the system is properly running at all times. Now, the first point that we need to bear in mind, Madam Chief Justice and the honorable members, is, did IBC formally gazette Gudino Omar as one of the persons who had access to the server? Secondly, IBC is enjoined under Article 81E to uphold the secrecy of the vote. How secret can the vote be if it is being constantly accessed by a foreigner from a distant location? What is the guarantee that this foreigner will not grant further access to other unauthorized persons to commit all manner of mischiefs? But more important, Madam Chief Justice and the honorable members, is the complaint by Justice Nyang'aya that Gudino Omar was uploading and downloading forms. There is silence with regards to that issue. Then there was the contention that other unauthorized IEBC staff also had access to the server. And their names were provided, Madam Chief Justice and the honorable members. In the replying affidavit by Hilda Kavonga, again, they make this admission. And with respect to one Abdidahir Maalim, it is argued, and I'm referring the court to paragraph 13, Roman 6 of Hilda's affidavit. She says, Abdidahir Maalim was a returning officer, and his access was limited to transmitting Form 34Bs and not to any other function. Madam Chief Justice and the honorable members, the list of all the returning officers, who participated are included in the affidavit of Juliana Cherera and specifically marked as Annex J C2. Unfortunately, the name of Abdidahir Mohammed does not appear. It is not indicated with respect to which constituency or which county he was the returning officer. It would appear clearly that there was a lie. Beyond that, the logs that were filed by Justice Nyang'aya were also analyzed by a forensic analyst, George Njoroge. And he submitted an affidavit to which he annexed a report. And in that report, Madam Chief Justice and the honorable members, it is clarified that Abdidahir Mohammed accessed the server more than 1,000 times. The question one would ask is, why would he access the server so many times? What was he doing? Madam Chief Justice and the honorable members, it is quite clear that the server was defiled. The next issue I would wish to speak to, and I can see I'm having serious time issues, is whether the IBC verified the results. And it is my submissions that that did not happen. And I'm saying so for two reasons. First, and this is important because it's not been captured by my colleagues, according to the Constitution, it is not only verification by IEBC that is required. Verification is supposed to happen at two levels. First, by IEBC, but secondly, by Kenyans. That's why both Article 86 and Article 81E institutionalize transparency. IEBC should make sure that every processes that they are undertaking are laid bare for the public to see, so that the public can also follow the processes and undertake their own verification. For reasons that have already been explained, it is clear that this verification by the public was not possible due to the opacity that has been referred to by my learned colleague, Apollo Mboya. But then there is the issue of verification by IEBC, which also did not happen and could not happen given the circumstances of this matter. Madam Chief Justice and honorable members, you have been told how 4 IEBC commissioners were sidelined in the entire process. It is our submissions that it could not have been the intention of Kenyans that IEBC commissioners be reduced to spectators in a presidential contest. That is something which is inconceivable. And we would humbly urge this court to put a stop to this practice. There are other issues that I would have wished to deal with, but because of time, allow me to cede the floor to to my colleague, Jeremy. Thank you very much.
It's my lady, the Chief Justice, and the honorable members of the court. My name is Gordon Ogola, and I'm representing the sixth respondent, that is Irene Masit. I'll rush through my submissions because I don't want to give more time to my brothers. I've been sent here by the sixth respondent to tell the court and the whole world that she's not coming here as a second-tier petitioner. She's not coming here as a surrogate of anybody, but she's coming here as a demonstration of her undertaking to protect, uphold, and defend the integrity of the Constitution. Indeed, while taking oath of office, she undertook to carry out her duties in compliance with the Constitution. In that regard, the sixth respondent was alive to the fact that in conducting the general elections, they had to be guided by the provisions of not only Article 81, 86, and 138, but also Article 10 of the Constitution. My Lord, the sixth respondent submits that the manner in which the election process was managed by the fourth respondent, up to and including the tallying, verification, and the declaration of the results, flies in the face of the provisions of the articles that I've cited. As will be seen in the affidavit of Irene Masit and corroborated with the affidavits of the other form commissioners, the chairperson excluded the majority of the commissioners from the tallying and the verification process. In fact, if you go through the affidavits, you will note that the only duty that they were assigned or that they undertook as regards verification and tallying was when they were summoned by the chairperson to be given the results in the office. My Lord, and the other thing that they only did is after he told them, this is the results I'm going to read, was to give them the Form 34C. They did not take part in the tabulation of what resulted in Form 34C. My Lord, the sixth respondent had a legitimate expectation that as stipulated under 138(3)(c, that the tallying and the verification ought to have been done by the commission and not by an individual commissioner in the person of Chebukati. In fact, the exclusion of these commissioners did not start at that point while they were in Bomas, but it started at the point when he, Mr. Chebukati, unilaterally reassigned them duties that they would take at the floor of Bomas, which were completely at variance with the duties that they were holding as in the subcommittees that were running at the commission. My Lord, before the declaration of the results, the commissioners were expected to ascertain and satisfy themselves that whatever was being put into 34C was a true reflection of the contents of 34A and 34B, but they were never given that opportunity. My clients and the three commissioners have confirmed that they were not involved in the process at all that gave birth to 34C. My Lord, even during the declaration of the results done by the four commissioners, evidence that can be found in the affidavits shows that the only things they were given were handwritten pieces of paper with results in them. Those documents that they were given and which they were reading out to the public are not part of any accountable documents that can even be brought to this honorable court. Secondly, at the time of the declaration, my Lord, you will note that there were 27 constituencies whose results had not been verified. Even though the chairperson claims that they could not announce or declare the results of those 27 constituencies because of the chaos that erupted, but they had an opportunity again when things were calmed down and they came back to declare the results of the presidential elect. Can it therefore, my Lord, be said that the process that led to the declaration of the results were transparent, were accountable, or were verifiable if indeed the declared results were accurate? My answer and the answer of the sixth respondent is in the negative. In respect to my client's position as to whether she accepts or agrees with the results that were announced, at paragraph 73 of her affidavit, she states that without verification of results from the 27 constituencies, I believe it was not possible to determine a winner in the hotly contested 2022 presidential elections, and to that extent, I cannot vouch for the veracity of the result declared by Wafula Chebukati on the 15th, for there was no transparency on his part towards the declaration of results and final figures, and were not verified. I was kept in the dark by the chairperson with respect to tallying. That is her position. She cannot vouch for the results that declared William Ruto as the president-elect. My Lord, lastly, the conduct of exclusion by the chairperson of the other commissioners from vital activities of the commission was not limited only to the events that happened at Bomas. I will just cite a few. One of them was the manner in which he assigned the commissioners' roles to play at the Bomas. That was a unilateral decision. Secondly, the unilateral deployment, transfer, and gazettement of returning officers nationwide. That can be found in the affidavits of the sixth respondent at paragraphs 16 and 17. Then the third one is the deliberate failure to facilitate the contract implementation committee to oversee the implementation of the ballot papers, contracts, and task of inspection of the printed ballots at the vendor's factory in Greece. That is a function that ought to have been done to ensure that there was due diligence of the ballot papers that were being printed. That one, again, they were not involved, and that did not take place. Lastly, second last is the postponement of the elections in specific areas, including Mombasa, Kakamega, Kacheliba, Rongai, Pokot, South, among others. And lastly was the appointment and gazettement of the chairperson as the national returning officer. That, again, is not a decision that was taken by the commission unanimously. My Lord, in the end, it is apparent that in managing the affairs of the commission with regards to the elections, the fourth respondent as the chairperson deliberately created a dysfunctional system to aid and abet his criminal and evil acts that would be interpreted to mean that he had intention to subvert the sovereign will of the people of Kenya. We beseech you, therefore, to find that nothing good can come out of a dysfunctional body. I'll therefore call my friend Jeremy to continue.
Yes, my ladies and my lords, I'll be very brief. My learned friends have touched most of the issues. My name is Jenga Jeremy, appearing for the eighth respondent. I want to give time to my learned friend Issa Mansul. So just a few points for clarification. One, speaking for the eighth respondent. My ladies and my lords, the eighth respondent per se, because of his position, is still a commissioner with the IEBC. He does not want to be classified as opposing or supporting the petition. But the reality is this, that by him, and I think that's the position of the other, from the fifth to the eighth respondents, by telling the court the truth, by telling Kenyans the truth, what happened at IEBC before the elections, during the elections, and after the elections, by telling the court the truth, Unfortunately, they have no apologies for this. That evidence addresses some of the issues that have been framed by the court. One of those issues that, according to the 8th respondent, is addressed by his position, the one that is taken in his affidavit, is issue number 6. That is whether the IBC carried out the verification, tallying, declaration of results in accordance with Article 138. My learned friends have covered that. The 8th respondent's affidavit has covered that. They were not involved in the tallying verification. So answering that question, the 8th respondent, it is his position that the presidential elections that were announced by the 3rd respondent did not comply. Now, the other issue that I want to clarify, my ladies and my lords, or maybe I should address whether the issue number 1, 5, and 7. Again, because of the peculiar nature of the way the IEBC is run by the chairman, it is the 8th respondent's position that despite being a commissioner, he cannot even help the court in addressing those issues because the results that were announced on the 15th of August, the system that had been put in place, the person who was in charge of them, it was not the commission, it was not IEBC, but that is the chairman. The chairman is the one who can be able to answer most of those questions. The results that were announced, his position is that those were not the results of the commission, those were the results of the chairman. Maybe the other issue that I should mention is that the 5th to 8th respondents, they've been branded all sorts of names. Some of them appear in the documents that are before court. Others have been mentioned out there. And my lord, what the 5th to the 8th respondents did by walking out of Bomas is because they did not want to give legitimacy to a process which they were not involved in. My lord, by taking my ladies and my lords, by taking the position they did, as has been mentioned by my learned friends, they took an oath of office. And the oath of office that they took was to uphold and protect the Constitution. When they realized that the Constitution was being abused, their role that they were supposed to play was being abused by the chairman of the commission, that's why they took that position. Did they take that position so that they could support any of the parties? My lord, that is not the position. They were just exercising their right, what they had taken oath to do, uphold and protect the Constitution. So all these names, the way they are being seen, that like they are taking sides, they are not taking sides because they had any interest in the outcome of the elections. They took the position they did because they wanted to uphold the Constitution. My ladies and my lord, we have there are some authorities in our list of authorities that we would kindly request that you look at them. I know you've been referred to authorities within Kenya. We have gone out of the country. We have some very good authorities from India, the Supreme Court of India. I will not take time to go through them, but they will be of great help to the court even as you retire to come down with your judgment. My lady, because of constraints of time, I will leave the remaining time to my learned friend, Mr. Issa.
Good evening. My Lady Chief Justice, the Deputy Chief Justice and Justice of the Supreme Court. My Lords and my ladies and my lords, in summarizing the position of the 4 commissioners who are now respondents in this consolidated presidential petition, Lords, we want to make the following submissions. One, as a commission, it is the position of the 4 commissioners that they did what was within their mandate to deliver a free and fair election as required by the Constitution. But in their quest to do what is right, what is required of them, there are problems that have been set out in the respective affidavits. And my lords, the first issue that you would note that springs from these 4 affidavits by the 4 commissioners is a question of lack of transparency. On the day after the voting ended, and also predates the general elections. You'd note one thing that is common and that cuts through the 4 affidavits is that they were excluded from the process that was going on in terms of verification. And what is clear when you look at all these 4 affidavits is that, yes, there was that process where they appeared to read results. These results, and they've said this under oath and has not been controverted, were the results that were being processed on the floor of the National Tallying Center. They were handwritten. And that's important because they were handwritten. They would come out and read them to the agents and to the nation so that for each and every constituency, and these results were per constituency, people would know that these results have been verified at the National Tallying Center. You would note that in this affidavit, for the first 2 days, from the 9th to the 12th, these results were being posted or they were being aired in a screen that was available to the agents, the presidential agents, and to the media. That screen was paused or it went off. In all the affidavits, they said and they requested that this screen should be on so that as we go progressively verifying and tallying the results, anything we announce here can be confirmed by both the presidential agents and by the voters who voted. That request was declined. The question is why? Why did the chairman refuse to put on those results and to verify the numbers that were being read to the nation? The second question that you'll see that arises in terms of the process of verification and tallying, that has been covered by some of the parties that have submitted today. You'd note that when that process reached the tail end, the 27 constituencies that had not been announced had not been publicly confirmed to have been verified. And in fact, when you look at the affidavit of Commissioner Wanderi, he says he had taken a break because he had been there overnight. When he came back, the first expectation was that these results would be confirmed, they had been verified, and that they had been announced to all the agents. The chairman takes the position there was no constitutional requirement or he had no legal requirement to do that. No, he had. Because the Constitution requires transparency and accountability. That is the process that takes place at the National Tallying Center. It is not a perfunctory exercise. It is not a ceremony. It is a constitutional process. And why this is important is that the document that was given to the commissioners by Mr. Marjan, as confirmed by Mr. Chebukati, was not a Form 34C. That was being undertaken not by the commissioners, but members of staff in the back office of the chairman. The commissioners did not see Form 34C, did not verify it, and they did not approve it before it was generated. In fact, in all of their affidavits, they said they never saw the Form 34C. What was given was a 3-page document, and that document has a problem. That document appears in the vice chairman's affidavit and the other 3 commissioners' affidavits. What you note about that document, and that was generated by Mr. Marjan, as has been confirmed, and presented to the commissioners, is a summary of 47 counties. It does not have the results that are required to be confirmed and verified at the National Tallying Center of the 290 constituencies. Why is that important? Because at this point in time, before the Form 34C can be generated, these 7 commissioners, and I'm talking to them as a commission, needed to verify that what we have announced before the nation and to the presidential agents these are the results that have been announced publicly, and this is what has been tabulated for each and every constituency, and these are the results garnered by each and every candidate. And on the basis of that, then a Form 34C is prepared. That 3-page document is not a Form 34C. That is a document that the chairman came with, or he was presented, and then he went and declared the result. That was unconstitutional because the Form 34C needs to precede the Form 34D in terms of the commissioners approving that document. And because that is their role, that is a constitutional role. In fact, we engage these commissioners, we invest the billions that we invest in the commission so that when this solemn exercise comes along, every 5 years, that process, they take it seriously and they do it in accordance with the law. And the third issue about transparency. The commissioners were not aware of how many voters, and that figure was not confirmed at the time this figure was being given to them. The figures, and you'd note about the different figures that have been given, and in fact, I was asked to highlight this. When you look at the affidavit of Mr. Sonkuli, sorry, let me start with the chairman, Commissioner Chebukati, at paragraph 30 of his affidavit, the one that he saw on the 26th of August, this is the one that has been prepared jointly by the firm of Gumbo and Company, my good friend. At paragraph 30, he gives the percentage 64.6. In Mr. Sunkuli's affidavit of the same day, and I know that an explanation has been given, on the 26th of August, at paragraph 25, he says at the close of voting, that the turnout that had been reported in Kimskits was at 63.6%, and he gives the figures. Now, the commissioners needed to verify and confirm what the turnout was. And that required, and this is in public knowledge, and it has been confirmed by all the commissioners, that in a number of polling stations, the Kimskit failed, and they, in compliance with the law, they resorted to the printed manual register. The number of voters who voted without being biometrically verified had not been verified and confirmed by the commissioners. In fact, that information was never given to them. The number of voters who had been confirmed as having voted biometrically had not been given to the commissioners. So yes, they cannot change any of the results, but the process of verification and tallying and the constitutional process of determining who has attained the threshold is a joint process by all the commissioners. And that's where they come and say, what is the voter turnout? They confirm that process, because yes, they cannot change anything in the Form 34, even if they see glaring illegalities, they can note them. 2, that transparency required, then they confirm, because this Form 32As are not transmitted electronically. They are brought by this individual, returning officers from the 290 constituencies. There was a possibility. There were some places where voters could not be identified because their biometrics had a problem, and they could not be. And then there was, and that was allowed by the Court of Appeal. The final resort was to resort to the register, the printed register, to confirm that these persons, because they had the IDs were registered voters. That is also a solemn process, because then they confirm, out of all this, were there any other voters that were identified manually, and then that number is verified so we can come to the determination whether the 50+1 had been attained. They were not allowed to do that. And they requested, it's not that because there was an oversight, they requested and the chairman declined. So this transparency at the National Tallying Center is critical, because as a commission, you have to come and defend the process from the Gazette notice that was issued in January of 2022 to the final declaration. And the fact that the chairman was stubborn is a question, as set out in these 4 affidavits, is that he has contempt not only for his fellow commissioners, but also for the voters, and also for the people of this republic, as well as the institutions. Because that's exactly what he was told as the chairman, not him as a person, in my inaccuracy that the chairman of IEBC does not have that role singularly. That is a role vested in the commission. Failure to adhere to a decision that is binding on the commission and the chairman of the commission is contempt not only of the Constitution, but of the institutions, of the judicial institutions that have said this over and over again. And let me go back to the lack of transparency in the process. When you look at the affidavit, which is the most detailed of the vice chairperson of the commission, there was lack of transparency regarding even when the ballot papers came to this country. The chairman calls the vice chairperson the night before the ballot papers are to land here and tells, oh, you are aware that tomorrow we are getting ballot papers. The other commissioners were not aware. This is part of the critical process that was meant to be undertaken by the commission. So transparency is just not at the tallying center, it's about the whole process. My lords, if you look at paragraph 8 of vice chairman of the commission, Juliana Cherera, she says, when it came to the issues raised about the voter register that were being addressed in one of the petitions, serious issues have been raised by KPMG. And so that required prompt, because this process was already late, it required a plenary decision on how to address the shortcomings and the lack of integrity of the data in that voter register. The vice chair says they were excluded from that process by the chairperson. So if there was any problem with the voter register, it was meant to be addressed by the commissioners because they take ownership of the voter register. They were excluded. He made the decision on how to implement the decision and even what to disclose to the public. So these are the processes we're saying. Transparency and accountability in the whole process, and Article 81 and 86, is just not about the final product that appears on the tally. It's about what the commissioners are meant to do. And lastly, when you look at the affidavit of Commissioner Justice Nyang'ai, if anyone was to be given access to the voter identification, the result transmission system, or the back end, the commissioners needed to know we are giving the following persons access and the following rights, so that if there's any query, they can answer on behalf of the commission. That information was kept away by the commissioners, from the commissioners. In fact, the commissioner in charge of that process. Lack of accountability and lack of transparency. And then these 4 commissioners who are being vilified are expected to come and stand behind the chairman and take ownership of such a process that has so many questions, and then confirm that a person has been declared the president without following due process under the Constitution. They took an oath, and they have a responsibility and a constitutional obligation to the voters and to the people of Kenya not to take part in such a process. And that's what they did on the day of 15th. And that day of 15th is important because if it was the last day, there could have been an explanation as to why the chairman was in a hurry. There was one more extra day. Why was the chairman in a hurry while the choir was singing, the country was peaceful? He had one more day to ensure that the whole process was undertaken in a manner contemplated under the Constitution. And so, my ladies and my lords, we submit that these 4 commissioners, and although they have taken a position here and they've now been, they've been sued as respondents, had every right not to give a seal of approval to that process that was not verifiable, it was not accountable, and had not been undertaken in conformity with the Constitution. They respect the work that all the voters, all the staff at the Commission had done, but they were betrayed by the chairman. Thank you, Chief Justice and judges of the Supreme Court.
Thank you very much. It is now time for the judges to ask any questions or clarifications in regard to the submissions we have had today. We expect the answers when you will be making a rejoinder. We are not expecting the answers now. It's when you're making the rejoinder. I will start with the Honorable Justice Hope.
Thank you, Judge President. I have three very short clarifications that I want to seek from the team representing the first petitioner. The first one, perhaps I can direct it directly to Senior Counsel James Orengo. What is the relevance of rejected votes when computing the results or the outcome of a vote? The relevance of rejected votes. The second one, I would have addressed it to Ms. Soweto, but the team can deal with it, and you are not answering us today. The postponement of elections in certain areas, and you say this resulted in voter suppression. That people wake up one morning to go and vote for a particular category of candidates, that I go to the voting or polling station to vote for an MCA, or is it called MC? That people go to vote for a senator, but not the other positions. Do we have any scientific nexus on this, or is it just an assumption that this happens? The last question for me is on the reliefs that most of the petitioners have sought. We were addressed by Senior Counsel Feroz Noroji and also Senior Counsel Professor Jenda on the reliefs or the relief in Section 80, subsection 4. And I'm wondering, what are some of the elements that must be satisfied before the court can act or can grant the relief under Section 80, subsection 4? That would be all from me, my lady.
Thank you. Justice Renara.
Thank you very much, Chief Justice. Thank you, Counsel. You've been most helpful to us, particularly to myself. I have three questions, four, I think, but very short ones. The first is to Senior Counsel Philip Murger. You addressed us on the PDF format of the forms, but in the pleadings, there is a JPEG question. Would you like to?
I would like to immediately correct that. It should be
Yes.
JPEG, not PDF.
Oh, okay. So it was JPEG. It was JPEG.
JPEG to CSV.
Okay. Would you then like to connect, because you addressed us, I think you didn't connect the JPEG to PDF and then you said CDF?
I will, but I'd just like to clarify that that was a mistake.
Okay, okay. All right. But just clarify when you answer so that we can get it right. And also in the context of the staging and tampering and so on, explain to us how that happens in real time. Give us, say, Kagera Primary School Form 34A. What exactly happened in your theory, because you say some of these things you don't have? How was Kagera Primary School interfered with the Form 34A? Number two, Mr. Arua, and this could also go to the other counsel appearing for the commissioners, you've raised many issues going way back before the election. The Venezuelans, mistreatment by the chairman, were not allowed to do this and that. But we saw your clients in public reading out results. And that's what I'm calling my acquiescence question. They did all these things until the 11th hour. What evidence do we have that this is not an afterthought, that they're not doing this in good faith? what evidence do we have, apart from the question of the instructions to counsel, the meeting they called? Why do we have anything showing that for the last 3-4 months, they documented these grievances and that there was therefore a storm brewing? My own sense of things is that when you come only at the point of final declaration, how then do we trust that in fact there were issues before? Tied to that, what role did violence play at Bomas? Because we have the evidence of the chairman that I couldn't do this because I was attacked, Gulier was attacked, we couldn't announce 27 polling station results, constituency results. What role did violence play at Bomas? I think you need to explain that as the commission, which is what you've said. For Firoz Noroji, Regulation 87.3, you've asked us to declare it unconstitutional, declare it inoperative. Please address that issue in the context of retroactivity and retrospectivity. At the time these things were happening, it was the law. You're telling us to now declare it unconstitutional. What happens to events? And you know what I'm asking about this. Mr. Ndegwa, you made a very innovative, I must say, submission regarding the diaspora vote, the number of constituencies. In answering my question, please go back to Article 89.1. 89.1 says there shall be 290 constituencies for the purposes of the election of the members of the National Assembly. We are addressing a vote in a presidential election. Please connect 89.1 with the presidential election. Otherwise, the way you left it hanging, someone would ask the question, what has this got to do with this court and the petition before us? I thank you, CJ. I thank you, Council.
Yes, let me just take up from where Justice Lenaula has with Mr. Ndwiga. Mr. Ndwiga, if you look at Article 38.2, every citizen has a right to participate in elections. How then do you reconcile that with your argument on Article 89? Because constituencies don't vote, citizens do. So again, prisoners, persons in the diaspora, how are they to be provided for if we are to follow your line of argument? My next question was to Philip Murgo. I was drawing a chart when you explained to us that what you're telling us is that in the evidence that you have is that the Form 34 went into the Kim's kit at the polling station to the constituency. Then between the constituency and the public portal, the Form 38's numbers were changed. They were changed in that sequence, if I'm to understand you. Now, I don't understand much about ICT, but I presume that at the polling station, when the Kim's kit takes the image, these forms are written in handwriting. How can you explain then, so that I can understand, how a form can be changed in handwriting? This is not typing, it's in handwriting. All these forms are being uploaded and changed, different people's handwritings. How does that happen? For Ms. Soweto, she's not here, but since we'll answer later, I was curious about the issue of voter repression and her arguments on that. If we look at the Constitution, Articles 136, 177, 180, each of these elections are separately provided for. So you have the presidential election, which has its qualifications, nomination process, even the dispute resolution process of a presidential election is separate, the governor is separate, the member of parliament is separate, the MCA is separate. And what happens when a voter goes to vote, they get 6 ballots. So it's 6 ballots into 6 ballot boxes. What we have then is 6 different elections, but on the same day. So if your argument is voter repression, then is the voter repression only to the presidential election, Or is that an argument that can be used by an MCA in Kakamega County to say that because the gubernatorial elections were cancelled on that day, my MCA votes have also been affected? Or, I mean, is it just the presidential election that the voter suppression argument is standing for? Or is it all? Because they are all separate elections. So how does one election affect the other? I think those are my questions for now. Thank you.
Thank you. Thank you, Chief Justice. Just a few questions. I think this could go to, I think, Mr. Orengo. You started us off with this elephant in the room, this 50% plus one. And I've read the submissions, I've read the affidavits. There is something still surrounding this question of voter turnout, the percentage. It's like the beginning of where the controversy is located. What is the relevance of the percentage of voter turnout to determining whether a candidate marshaled the magical number? And then back to Mr. Murgor, this staging. Again, I've been intrigued. I've been reading. If I understood you correctly, and if I understand the affidavits correctly, we are having this Form 34A. The original, which is filled, leaves the polling station to go to the National Tallying Center by road, let's say, for ease of understanding. Its image leaves to go to the same destination, but this time by air. Somewhere along the line, in mid-air, the image is captured. And then all sorts of things are done before it is re-uploaded, which means, therefore, if you go to that captured image, which has been re-uploaded, you will find different content from what it had at the polling station. So to determine whether that has actually taken place, you would have to go now to the tallying center and locate that one that left by road and compare. Is it possible that that capturing in mid-air also somehow magically changes the content of the one that left by road? Okay, just because I just want to understand. Then let's get back to the 4 commissioners, because this is serious. We were informed by, I think this must have been Mr. Nyamodi, quite graphically, that the 4 commissioners were allocated roles other than those for which they were appointed as commissioners. Some were heads of protocol, I think others were media, welfare. Interesting stuff here, allocating such roles to commissioners. Why didn't they protest? Is this chairperson we are dealing with such a terror that nobody can face him and tell him you can't do this? Because now what we are hearing, these are serious disclosures. Because you can imagine I being, but because I was annoyed by, upset by my friend Willis for having tried to compare that way. So I'm just wondering, why is it that very serious Kenyans did not seize that chance and protest to the Kenyan people that what we are being given, the roles we are being assigned, have nothing to do with tallying and verification and carrying out our constitutional mandate. I think this is tied to my colleague here, is why to the tail end? Because I'm sure the voter out there also wants to know. So let me leave it at that.
Thank you, Honorable President. I have a few questions. And the first one would refer to the lead petitioner, or rather the main petitioner, the first petitioner, if I may say, in the lead file, which actually initially was petition number 5, E005, Raila Odinga and Martha Karua versus the respondents. And later on, after consolidation, it became the lead file and file number 1. I'm concerned with the reliefs that are sought, the alternative relief sought. The first relief relates to the issue of scrutiny, which is ongoing, and the issue of the threshold, constitutional threshold of 50+1. And after the inquiry, you would like that after the scrutiny, election, and the inquiry on the election technology, all the claims which have been made, and that after there should be nullification of the results, and then an exercise of recount, and after the recount and tally, that the chair be directed to declare the petitioners as the petitioners, that's the two petitioners, Raila and Martha Karua, to be the successful, or to be the winners of the elections. That's one of the. So I was saying that we would like you to lay a basis, legal basis for this in your rejoinder. No remedy that has been pleaded is going to be taken casually. Every pleading, every relief that we have sought, we are taking it seriously as a court. Therefore, because you will not just do it cosmetically, you must be meaning it. So is this doable? Is this feasible in law and in all other practical ways? We want justification, and from, I think even suggestions were there in 2017, but now we are here. So I would like you to firm up that and give us, justify the legal basis, the constitutional basis of that, and whether lawfully, constitutionally, that is possible. Of course, we'll be coming to the issue of the capacity, after all the allegations, the capacity of that chair carrying out to be in charge of the exercise of the next process, if you are successful. But before that, okay, there's the alternative that if that's not workable, then a fresh elections take place. Now, that's the problem I'm having is that, and if an election is to be ordered to be done now, yet one of the reliefs you are seeking is that the chair and substantially the commission, but effectively the chair, you want us to hold him or to declare that he is not fit to hold public office because of his malfeasance, because of his the illegalities, irregularities, even allegations of fraud that he has perpetrated, that is not fit to carry out that exercise, to be in charge of such elections. Our Constitution, I believe, has never contemplated and envisaged such a serious situation, such a lacuna. And you know, we are all peaceful, loving people. We believe in the rule of law. We believe in constitutionalism. How is that possible? What are your proposals practically on the ground? If suppose this was done, how do you want us to navigate and apply the law? Is that possible within the law? These are serious issues. These are serious remedies you're asking for. In the meantime, what is the de facto state? What is the status quo? Is that underpinned under the law? These are the questions that we would like to ask, because as you know, in Kenya we have never had a state of emergency. and we all never contemplated, and I don't wish to think about it. Finally, yeah, actually, that is all. Because the other questions have been asked quite exhaustively by my colleagues. Thank you.
Thank you, Judge President. The challenge one faces when they talk about the same subject at the end of a conversation by many people is that they find themselves repeating issues. But I will still ask what I had noted down during the proceedings, and you can choose the manner in which you will answer them. For Tim Orengo, my concern is, and actually for everyone who has spoken about the commission, what we have heard is what, about this commission, is what some time back we had someone describing, was it an accident or something on TV, and we were told it looked like a video and drama. At least that's how I perceived the submissions on the commission. And so my concern is, when did this commission become this dysfunctional? The effect of becoming that dysfunctional? What corrective measures were attempted, if any, and with what result? My second concern is from 34A. Minor Kia told us that this election is done not at Bomas, but at the polling station. And for the presidential election, the return of that form is first by electronic transmission. And so, the way I understand it is that a photo would be taken of the form at the polling station. A photo. I want you to tell me whether it's called a photo or what it is called. Is it called a photo? Is it called an image? Is it called what? That's the question I'm asking. And so that time when it is taken, and as it is being sent originally, is it in PDF form? So the journey, because this has to be understood, the journey from the polling station to Bomas, the things that happen in between must be described by the nature of that image at the original place, at the starting point. My other concern, which ought to have followed the first one before this PDF language, is what is to be done as a corrective measure against the chair of this dysfunctional commission. And is it to ignore the constitutional procedures and safeguards that are already in place? My final concern is concerning the relief to declare. What I have heard since morning, because of the dysfunctionality of the commission and a few other things, is that nearly everything about Articles 81, 86, the Act, have been impugned. In fact, one of you told us that everything that could possibly go wrong went wrong. So if every process that was undertaken in this process has so far been impugned, are we nevertheless to declare a winner? Are the figures, in the event that we arrive at figures that show that either the current president-elect has more votes than others, and or the petitioner in petition number 5, in fact, has more numbers, what are we to do? Are we still to declare? Irrespective of all the other processes having been impugned as you have submitted to us today. If you assist me with some direction in those issues, I shall be in a position to deal with the petitioner's case. We'll see what we will do with the respondents when their time comes. Thank you, Judge President.
Thank you. I think all the questions I had have been asked, but I'd just like to follow up on what Justice Ibrahim asked. The team on the Reid petition. They have been called Team Senior Counsel Orengo. You have asked us to find the chairman culpable of various breaches of the Constitution. And as Judge Ibrahim explained, you have even told us to find that he cannot. Should we find that there should be a repeat election, he cannot preside. My dilemma is, this is a constitutional office order. Under Article 251(2) of the Constitution, there is a detailed procedure that is provided for the removal of a constitutional office order. And what I would like you to address us is, how do we go about that? Would we be making an order that is contrary to the Constitution? Because like the judge was explaining, we are a country that believes in the rule of law, in the right of a person to have a reply, to be tried. So, you know, for the breaches that EOC has committed. Mm-hmm. And that is also related to the issues you have also cited about criminal culpability. I want you to address us on, because we have an Election Offences Act, so that if somebody has committed an election offense, they ought to have been charged and tried before the court with the jurisdiction. In this case, I know we gazetted some magistrates to deal with election offenses, and my question is whether we wouldn't be usurping the powers of the magistrates if we have to make any order regarding election offenses. Then to the team led by Senior Counsel Mr. Mwite for the 4 commissioners, I still want to understand at what point the commission ceased to function as a corporate entity. Is it when the 27 constituencies were not announced? Or is it when, I am really trying to understand that, because we saw them announce regularly the results at the plenary in Bomas. We really want to understand, like the Vice President is asking, when did the Commission become so dysfunctional? We really want to understand that. Is there a stage where they were working together in tallying and verifying, and then they went and announced, and then suddenly there was a stoppage because the announcements also stopped streaming live? So we really want to understand that. Then my last clarification will go to Mr. Kibe Mungai. And I want you to answer this and tell us how you know that IBC did not make arrangements for certain categories of people to vote, especially the IBC staff. How do you know they did not vote first before they started the exercise? Because they were in a polling station, they could have transferred their vote to the station where they were conducting the exercise and voted. Because this seems quite subjective, so you needed to explain more that 700,000 people did not vote because IBC did not make arrangements. I think those will be my questions or clarifications that I will be seeking from Council.
Justice, I have one follow-up. May I piggyback on your last question? Section 6 of the IEBC Act, 6.1, says that the chairperson of the commission shall be a person who is qualified to hold the office of judge of the Supreme Court under the Constitution. Then 7A says that the chairperson or member of the commission the office shall become vacant if the holder dies, resigns from office by notice writing to the president, or is removed from office under Chapter 6 or Article 251. In that context, if perchance we were to order removal of Chebukati as chairman, would the commission still be intact with the remaining 6 commissioners without a chairman of that qualification? I'm just wondering for my own sake. Thank you very much, Chief Justice.
I think that brings us to the end of today's proceedings. It was a long day.
Permission, Madam Chief Justice. There is still an issue arising out of the scrutiny. I am told I would like my learned junior to explain, because he's the one covering the technical issue of the scrutiny.
Good evening, my lady, the Chief Justice and the Honorable Judges of the Supreme Court. My name is Eric Gumbo. We've had interaction with my colleagues who are handling the scrutiny, and they give us the indication that there's been very good progress so far, but there's one specific issue which they would want to get clarification from this court on that arises from Order Number 2. Specifically, the use of the word forensic image. Now, the applicants appear to be interpreting that to mean an opportunity to get the image of the entire server. Now, that is causing a bit of a concern, because then it means if they have the image of a server, technically, they'll have gotten access to everything that certainly is contained in that server. It means that that order will be so far-reaching that after that event, it may not be possible for the IEBC to use that server again. It then particularly concerns the Commission, because if perchance there was an order for a repeat election and you don't have that infrastructure, it then means that that election may not be conducted. The other concern is the potential breaches that might be in relation to third-party licenses that are contained, and so therefore it really is important that we get clarity on that question so that then the exercise can proceed smoothly. I am most obliged.
Yes, with your permission, Madam Chief Justice, ladies. I raise because after we broke off over lunchtime, I personally went to the IEBC offices, 21st floor, where the exercise was going on. And I'm sorry, but I don't think what my learned friend has said is exactly what was going on. First, the team that was sent by this court to supervise did come up with what was an implementation matrix and laid it out. I think this was done yesterday. And what I learned is the biggest problem that has been going the whole day are arguments about this implementation matrix. And as by the time I left at 3 o'clock, nothing had happened. And even some of the simplest issues as giving copies of the technology system security policy had not happened. So what I met is an argument between technical computer people about what they should comply or not comply with, about what forensically, for instance, the issue of the forensic image is not correct that the demand was for an image of the entire server. In fact, what I meant had been agreed on was that the part of the server that was supposed to be forensically imaged was going to be cloned so that there's no access to and that had also been agreed on. But when it came to implementing it, there were always new arguments. And in my estimation, what I found is that there is nobody at IEBC who this order is directed at, who is responsible for ensuring that these matters are done. The CEO of IEBC was there, the director of ICT was there, there were 2 or 3 lawyers from IEBC and a host of other technical people. And all that was happening was arguments happening between one team and another team. The CEO says this, but he doesn't talk, so other tech people come, argue with the people from the political parties. That is the confusion that is going on. And therefore, unless this court addresses its order at a specific person, who then can come in case there is doubt as to what these terms mean, can themselves come for clarification, then that confusion will go on. But either way, we did try to sort out the problems that were there. I left at about 4 o'clock, the process now starting. The advice I give to the team is let us first see what happens in the several hours, and then they will say what is it they are not getting, and we can report that to court. I will be going there after this to find out how far that has gone. I still feel very strongly that this court needs to make somebody from IEBC responsible for the implementation of this order. Thank you.
My lord, sorry. Without appearing to belabor the point,
being given an example of one of the issues that arose is because there's also an argument going on as to how many servers are involved. There was talk of only accessing one server, then there's a whole range of technical arguments as to how many servers are involved in an RTS and how many should be shown. Our team is saying that there are about 8 servers involved, that they've only gotten access to 1, that they're not getting access to the other 7. There's nobody at IEBC who takes responsibility to answer that question, so nothing gets done. Thank you.
Sorry, my lady. Sorry, my lady and my ladies and my lords. Without appearing to want to belabor that point too much, I think when we got back after the short break that the court took, Justice Lenola did indicate that there was fairly good progress in all the fronts, both in For Other House and in Anniversary. So it certainly cannot be true what counsel is saying, that there has not been progress, because then that would impute that counsel is even saying that the court is not saying what is happening. We have gotten very clear indications that there's been, there are 4 compliance items that were raised. There were 4 compliance items that were raised. Out of those 4, item number 2 has been resolved, item number 3 has been resolved, item number 4 has been resolved. That is the current update that we are getting from our team. The only item that is outstanding is the question of forensic image. And I think there's substantially good progress. It is not accurate to report that there's no progress. We have our director of ICT who's personally taking charge there and is the one who's updating us on what is happening. I think if we could get a clarification in relation to what that forensic image is, then we will be able to complete the exercise. I'm most obliged.
Thank you, Council. I think from what we understood when we took the break for lunch and when we came back, the issue of order number 2 had been resolved by the question of cloning as opposed to the security question of forensically imaging the server. So what we gathered, and that's what I said when we came from lunch, was that there is progress. Let us revisit it later today after we leave here. But as far as we were concerned, the resolution was that they'll do some cloning, and then any concerns that this team would have would then be presented to us tomorrow, having also gotten a report from our team. But at the time we came, there was good progress, and that's what Mr. Gumbo is saying, so far as we knew from our team out there. So perhaps, CJ, the way to go, let us go back ourselves, perhaps get our report from our team, and should there be any need for a direction tonight, we could do that remotely. And if not, then we give a report in the morning, because we gathered that the progress was immense and that something would be perhaps actually finalized tonight. I think that's the best way to go, instead of us going back and forth. And we don't have a report from our team. So would you allow us to do that? Then we come back to you. Thank you, CJ.
Thank you very much. I think fatigue has settled until even my own gown has tethered me to the seat. I cannot move. But with that clarification, and just to remind ourselves that our team is led by the registrar of the court, who is going to make a report to this court. Council Paul Mwangi, I think what you are making to us was a kind of a report. So let us see how we can cooperate and get the best evidence that can assist the court. With that, allow me to wish all of you a good night and look forward to seeing you here tomorrow at 9 when we start the questions will be answered in the rejoinder. Yes, have a very good night.